Today's episode of Socially Democratic is presented to you by Dunn Street. Dunn Street is a progressive campaign agency that specialises in campaigning and community organising. We work with non-profit and community-based organisations, trade unions, progressive businesses and social democratic parties across the globe. Dunn Street provides community engagement and organising strategies to win campaigns both big and small. And Dunn Street trains engagement staff, volunteers and organisers in leadership and power building. And if you want to create change in your community in 2023, hit us up at dunnstreet.com.au. Today's episode is also proudly brought to you by Maurice Blackburn Lawyers. Are you passionate about extending access to justice? Maurice Blackburn has an excellent opportunity for a union partnership manager to join the firm on a 12-month contract based in Melbourne. It's a high-profile opportunity where you can bring passion and enthusiasm to a role that will see you drive and promote the Maurice Blackburn ethos to help reach more clients in need. To find out more, go to mauriceblackburn.com.au/careers. And finally, today's episode is brought to you by SwiftFox. Every moment on a campaign matters. You need the tools that you can trust, lists that are up to date, phone banks that can change minds, emails that drive donations, events that will energise the community online and offline, and text blasts that distills your message perfectly. SwiftFox CRM is made for campaigners by campaigners. And to find out more, simply go to www.swiftfoxcrm.com to win your next campaign. Hello, and welcome to another episode of Socially Democratic, your weekly centre-left politics and organising podcast that's out every Friday that dives into the progressive campaign issues of the day and the folks that are leading them from home and abroad. And we go overseas, but we're talking a bit about stuff that also relates to the work here in Australia. We're joined by Dr. Julie MacFarlane, who is an academic, a lawyer and a researcher, and is also the co-founder of a campaign called Can't Buy My Silence, which works towards fighting the use of exploitative and harmful non-disclosure agreements. And she's also joined on today's podcast by someone that we all know, Liberty Sanger from Maurice Blackburn Lawyers. Obviously, you'll all know Liberty from our annual International Women's Day mic handover episode. And the two of them are on today to talk about NDAs, why they're a bad thing and how we need to get rid of them. So look out for today's episode on that hot topic. Don't forget that if you like the show, to subscribe to the podcast on Apple Podcasts, Spotify and Stitcher, and to give us 5 stars on Apple Podcast when you're done listening, or leave us a wonderful review on Apple Podcast or Podchaser. And for all the updates, follow Dunn Street on Facebook, Twitter, Instagram, YouTube and LinkedIn. Okay, let's get to today's episode. We are taping this one on a glorious Tuesday afternoon on the lands of the Wurundjeri people, proving that God is indeed a Victorian. And we're enjoyed by two wonderful guests to unpack the topic of non-disclosure agreements. And first of all, we're joined by Dr. Julie MacFarlane, who is the co-founder of Can't Buy My Silence campaign, which is working towards fighting the use of exploitative and harmful non-disclosure agreements. Their campaign is to stop the misuse of NDAs so that they are only used for the purpose for which they were originally intended, which is the protection of IPA and trade secrets. Julie, welcome to Socially Democratic.
Thank you, Stephen.
And we're also joined by someone who is no stranger to this podcast, who hosts our annual International Women's Day mic handover episode with Nat Hutchins and Julia Fox, I should say, and she leads the National Personal Injury Compensation Department at Maurice Blackburn Lawyers. But more importantly, she's a former NUS Victorian State President and fellow La Trobe Uni Labor Club alumni. Liberty Sanger, nice to have you on the show at the same time as me.
Hello, Stephen. Welcome. That was quite the introduction, and thank you for anchoring our relationship back in the important days of La Trobe. That's quite a significant part of my journey to date.
Absolutely. And it's great to have you on the show simultaneously as well. So we've got a fair bit to get through today. So let's dive straight in. But I want to start with you, Julie. Share with us a bit about your background and how did you find yourself campaigning in this particular space?
Okay, well, thanks, Stephen. Well, I have been a law professor for 40 years. Obviously, I started when I was extremely young, like about 4 years old. But I have now resigned my position as a distinguished university professor of law in disgust at my university's use of non-disclosure agreements, specifically to cover up passing on a predatory sexual harasser, a faculty member. And I'll say a bit more about that in a moment. The work that I've done over the last 40 years has been mostly anchored in a lot of qualitative research, empirical research. I've been very interested in looking at the ways in which people experience the legal system, not just as lawyers, but as clients of the legal system. And the most recent project that I've worked on before this campaign was with self-represented litigants, of whom, of course, you have a lot in Australia, as do we, because of the cost of legal services being out of reach for most people. I launched the National Self-Represented Litigants Project, which we do have some Australian visitors to our website. It has a lot of information and resources that would be useful probably for people from Australia as well as Canada. But more recently, I have become involved in a very full-time capacity. I think, it's about a 12-hour day most days, in working on this campaign, Can't Buy My Silence, with my partner, Zelda Perkins. And the reason that I was drawn into this was because of my own experience, as I mentioned, of seeing a non-disclosure agreement used to cover up the termination of a colleague following numerous student complaints and an investigation. And I went from being extremely relieved that the university had terminated him to being extremely angry when I started to get phone calls from other law schools in different countries, which told me that no one had explained why he'd left, and he hadn't explained why he'd left. And immediately the penny dropped for me, and I realized he'd been given an NDA. So that preoccupied me, trying to pursue that for quite a couple of years afterwards. He sued me for defamation. There were all kinds of fallouts from this. And when I couldn't get my university to change its mind on what I thought was a very dangerous and immoral practice, I resigned and joined forces with Zelda, who is based in the UK. I'm based in Canada. And we began this campaign to try to get legislative reform to ban non-disclosure agreements. And I can explain, obviously, quite a bit more about the milestones we've been able to reach in the last 15 months, because we've seen enormous change in this particular area already.
And I look forward to unpacking that with you, but I'll go to Liberty next. Lib, I just want to get a sense from you about your interest in this issue. Where did it begin, and how did you two, yourself and Julie, first meet?
Thanks, Stephen. Well, as you know, I've spent my professional working life here at Maurice Blackburn working for workers, and particularly looking after them after they've been injured at work, and thinking about why it was that most of the time when we saw injured workers, we were seeing people with physical injuries, when we knew that there were a lot of people, mostly women, and certainly if you had more than one attribute of disadvantage, even more likely. So, if you were from an Indigenous background or had a disability, we were seeing many victims of workplace sexual harassment. But strangely, those victims were not coming to the work cover department of Maurice Blackburn. They were going to our Employment and Industrial Law Department of Maurice Blackburn. And so, for reasons that were never clear to me as a young practitioner, I wondered why it was not the case that the employer's duty of care when it came to safety at work didn't seem to be the mechanism through which justice was sought for victims of workplace safety. Fast forward to my now 25 years at Maurice Blackburn, and over that time, we've seen a lot of things happen. If I take us to the Kate Jenkins Respect at Work report, where there were some quite significant recommendations made about how occupational health and safety laws should be used in order to prevent sexual harassment occurring in the workplace, and also that non-disclosure agreements should be discouraged, and that employers should enter into a code of conduct around how they were used. We find then the Victorian government setting up a task force to figure out the nuts and bolts of how is that going to work in practice. And Ingrid Stitt, the minister at the time, asked myself and Bronwyn Halfpenny to co-chair a task force on that. And I jumped at the chance because for me, it seemed that this was bringing together all the activism and campaigning that I've done over many years, either for workers or for gender equality, and getting this issue of workplace sexual harassment into its right place, which was how do we make sure that we equip workers to use the tools that already exist and are very well understood by employers to prevent workplace sexual harassment occurring, just as they do and employers do when it comes to how to stop injuries happening with machinery or other heavy lifting work practices, for example. So myself and a number of others, we had representatives from employer groups, union, community, migrant groups come together and look at our OHS laws and what would need to be done to enliven them, to ensure that they were capable of being used and understood to be capable of being used for workplace sexual harassment. And then looking also at this question of the confidentiality agreements or non-disclosure agreements, they go by both names in Australia, look at how they are used as a tool to silence victims, to cover up poor workplace culture, and what could be done to make sure that they were not used in such a way so that we could address this issue of workplace sexual harassment.
How prevalent is workplace sexual harassment in Australia? I think you guys might have spoken about this on some of those International Women's Day episodes we've done in the past, Lib, but I just want to get a sense to refresh our audience about exactly the extent of this issue.
Well, the last survey undertaken by the Human Rights Commission showed 3 in 5 people report experiencing workplace sexual harassment. And I would suggest that's underreporting. The Victorian Trades Hall Council, with their own survey, found it's close to 70%. We know how difficult it is for people to report workplace sexual harassment, so identifying that they have been a victim of it is challenging. We also know that there is still a little bit of uncertainty about what sexual harassment is, and so many of us have become accustomed to letting comments and behaviours go past us in order to just get on with the job of being in a workplace and being included and being able to do our job, that so much of it doesn't get recorded even by ourselves as workplace sexual harassment. So it's extremely prevalent, and I would suggest even more so than the reporting tells us.
And if I can just jump in here, Stephen, I mean, I think what we're talking about here with sexual harassment, and we are going to be talking about in relation to NDAs, is power. Because, you know, inevitably, this is the behavior of somebody in a position of power and authority over another individual. So, for example, a professor and a student, but also, all kinds of other power relationships within the workplace. And I experienced sexual abuse myself when I was much younger by an Anglican church minister. And again, you know, this is somebody that you see as having a lot of power over your life, a lot of authority, cannot be challenged. And I think it's really important to underscore what Liberty is saying. It's extraordinarily difficult for people to step forward, both to recognize and then to step forward and to report, because there is still a sense of shame associated with doing that.
Listening to those figures that Liberty was just sharing there and your extensive research outside of the Commonwealth of Australia, do those numbers bear out in your experience in places like Canada and
Oh, Absolutely, yes. I mean, we're hearing. I mean, there are many studies that say 1 in 3 women have been sexually harassed or experienced some kind of sexual violence. And I think that what people also don't realize is the extent to which this is controlling behavior, whether that's within a workplace, whether it's within a domestic situation. But it is, a tried and tested way of men controlling women, and it's extremely prevalent. Yes.
Sticking with you, Julie, can we turn to NDAs? What is a non-disclosure or confidentiality agreement?
Well, a non-disclosure agreement, as I'm going to call it, and the only reason, I mean, Liberty is right. Both terms are used synonymously, but I think we've seen quite a lot of people using the words confidentiality agreement to make it sound like soft and squishy and really okay, whereas I prefer non-disclosure agreement because that's more of a statement of what it is. A non-disclosure agreement is an agreement by one or more parties that they will say nothing about the circumstances under which their settlement has been reached. So let's say, for example, Stephen, somebody brings a complaint in a workplace, a complaint about sexual harassment, or indeed a complaint about racial discrimination, about bullying, pregnancy discrimination, disability discrimination. And instead of that complaint being fully addressed, they are offered a severance package, usually a very small one, and they are required to sign an NDA. We have plenty of data that shows us that people who bring complaints in the workplace, those who have been brave enough to bring that complaint, almost always end up leaving that workplace, and that perpetuators of the misconduct are the ones who stay. And what the non-disclosure agreement does is it says to the person bringing the complaint in a workplace context, if you want this all to stay private, and for your name to be kept private, you have to reciprocate. In other words, you have to agree to keep the name of the other side private and not talk to anybody. Typically, that's family or friends, colleagues, even therapists, about the circumstances of what has happened to you. And if you do so, this amount of money we're giving you, which again, I want to emphasize, we have lots of data showing that these are $10,000, $15,000 settlements. We're not talking about millions here. If you were to speak about this, that would be regarded as a breach of that agreement, and we will take all the money back from you again.
What was the original intention of these non-disclosure agreements?
Well, they arose originally out of the huge expansion of tech and the development of software and platforms in the 1980s in California, what's often called the tech boom. And in those cases, obviously, there was a lot of pressure to try to keep secret information and tools and developments that have been developed in-house by different organizations, what we would loosely call trade secrets. And the courts at the time tended to look rather unfavorably on efforts to do what the law previously allowed, which was to put a restraint of trade agreement on an employee to try to ensure that they would not share that information with a competitor or go and work for a competitor and take the information with them. NDAs were invented because they were forever. Whereas the courts was generally saying this can only be for a reasonable period of time. It might be 3 years, it might be 5 years. And the feeling was we want to protect these secrets forever. And as a result, the indefinite device of a non-disclosure agreement was born. But what has happened is that probably within the last 10 years in particular, we have seen the creep of the use of NDA away from just trade secrets and into every form of misconduct in the workplace. So anything that might cause the employer reputational damage or anything that might reflect badly on the perpetrator, there is now enormous pressure put on victims or complainants. In fact, it's just assumed that they will do this as a default, to sign a non-disclosure agreement and to agree to never speak to anybody ever again about what happened to them, as if it was a trade secret.
It's funny, when I was a young union organiser, every now and then we had to do industrial work. And my first introduction to an NDA, I think, was for a worker in the retail sector. And it just didn't feel like there was equality in the agreement. You know, I felt like the company were they made out that they were making concessions, but it didn't feel like there was concessions being made. And I felt for them. I felt for the member. I thought to myself, this is the workers losing out here in this agreement. And it was only years later, actually, when I ended up working for another union, a major Australian company had a particular site in Adelaide, and the manager there was he was a shithouse human being, to put it bluntly. And he and his upper management were constantly having to sign NDAs. Either he was covering up for his mates, or he was signing NDAs for his own behaviour. And it just dawned on me at that moment, saying, this staff is moving through this office, this workplace. No one knows about the culture in this place because of these NDAs.
Correct. Yeah.
You know,
Exactly.
these guys get to behave like this, like they were absolute cowboys. Like it was the 1950s the way they were behaving. And it just
I don't think it's very different now, quite honestly, Stephen, because the prevalence of NDAs is even greater now than it would have been then. As somebody who's been a union member and an activist my whole life, I am horrified by the extent to which unions have bought into NDAs. But I think that they have largely done it because they are unaware of the long-term impacts that they have on people. Although I think if you just stop twice to think about it, you might realize that. And they are definitely a naked assertion of power by these more senior folks who are able to maintain and preserve their own so-called lily white reputation, but they do it at the expense of the people who are being NDA'd. So if you raise a voice to say that you want to make a complaint, this is likely to be your path out of there. And in the pressure of very intense bargaining, if somebody's brought a complaint, it's a very difficult and traumatic thing to do. And I know this from my own experience as a civil litigant in relation to sexual abuse. And therefore, people sign. They don't necessarily understand what they're signing. It may be weeks, months, or even years before they realize what they've signed. And it's a way of keeping them silent about the abuses that are going on. So in other words, everything that we've been trying to encourage through the metoo movement for people to come forward and report these kinds of matters, Black Lives Matter and so forth, we are reversing that and shoving it back under the rug again. And this is, greatly chilling and discouraging people from bringing forward complaints at all, because there is now a widespread anticipation, and our data shows it's almost a third of people do not make a formal complaint because of anticipating they'll be asked to sign an NDA, and they don't want to do that.
And Stephen, if I could just chime in there and pick up on something you've said too, because I think that's really important, and it's not just something that a young union official finds, it's something that a young lawyer, or this young lawyer, me, found when I entered the law. You arrive in an operating environment and a culture, and you learn about what the requisite ingredients are to bring about a settlement. And, that's been passed on through generations, and it's not with any ill will or malice. Obviously, on the sides that we've been representing, Stephen, we're out there trying to strike the best deal for our client or the member. But without knowledge of the history that Julie's just told us about where these NDAs came from and what they were really designed to protect, you don't have reason to question the ethos that this is the only way to strike the best deal for the member or client. And I have to say, this work that I've done on the task force really gave me reason to think deeply about, how have they ended up becoming such such a critical part of obtaining a settlement for a person. It just hasn't been questioned. And I think one of the things that has started to emerge is that we're seeing early signs that some lawyers, and certainly the Maurice Blackburn lawyers, are pushing back on the request for a confidentiality agreement and being thoughtful about, what is it that each party wants to keep confidential. I mean, this will go to the heart of what we now go on to talk about. But I did really want to make the point for the listeners, because there's probably quite a few out there who are thinking, oh, I'm seeing these all the time at the Fair Work Commission, or I'm seeing these all the time in my day-to-day work as a union official. Please don't slay yourself. We're seeing them all the time in the legal profession too. It's up to us as activists to now start pushing back and asking for them to be removed, and where they won't be removed, really cross-examine why it is that they might be required, and to give your member or client advice about what they could do next if they refuse to sign one. But it is appropriate to question, as you did when you were first first employed as a union official, why are they there, and is the power balance fair, and does this feel right?
And just to add to that, Stephen, I think the other thing that people don't necessarily understand or realize is that it's perfectly possible to protect the victim's confidentiality and privacy without an NDA. An NDA, as I said earlier, is a reciprocal agreement where you have to basically agree to protect the other side and keep silent about their behavior for them to keep silent about you. There's no reason why that should be standard practice. What should be standard practice, however, is that there is a privacy, a confidentiality guarantee for the person bringing the complaint, but there's no reason why that should have to extend to the other side, especially since that simply allows the continuation of this behavior. And this has become so widespread that there's even an expression which, is slightly vulgar, but I think really puts it where it is, which is pass the trash. And passing the trash means passing somebody on to another workplace, or perhaps passing them to another department of the same workplace without anybody being warned about their behavior, so that they will then, and we know this as well from research, this kind of behavior tends to be serial. And they are very likely then to be doing the same thing another time. And I think that for unions that I'm working with now, there is increasingly, the recognition that, this seemed to be just part of the job. We always signed off on these things. And now, oh no, this is a problem. This is really exploiting the vulnerability of the complainant.
It's funny, speaking about this now, I'm now going back to a whole bunch of different examples of it in, my time as a union organizer. And sometimes it was never black and white, sometimes there were complexities in the workplace. Sometimes maybe an employee has acted out inappropriately, but they're lashing out after being frustrated for a number of months or years at the treatment that they were getting from people within power. So they think that they're getting tripped up and they're saying, well, we're going to terminate you based on your behavior. But when you speak to the member or the worker, they say, well, no, I did that. Well, they're not as clear as this, but they're saying, yeah, sure, I did do that. But that prick has been on my case for the last 12 months and I've had enough.
Right. And I think this points to a systemic issue, which I know Liberty encounters in the work that she does, which is that we're still in the place, even though it's 2023, that employers are not very good on picking up on complaints when they're first made. I mean, one of the main reasons that so many employers want to sign NDAs is because if it came out that they've actually been sitting on complaints about, as you put it, this prick for years, they're not going to look very good. Whereas if we actually had a system of responsiveness through a positive duty that the employer had, and people wouldn't feel so frustrated that they were being ignored, then I think some of the issues that you're talking about, you're describing, Stephen, wouldn't happen. And I also know that the whole process of bringing forward a complaint, because it usually is very bureaucratic, it's very lengthy, it's very protracted, is an incredibly isolating and often traumatizing experience for people. So, they're probably not on their best behavior by the time it's finally all done.
There's an interesting point that Liberty mentioned in her remarks just before. So, Julie, I want to get your thoughts on this. Like, why doesn't self-regulation work in terms of stamping this out? Why don't laws push back?
That's a really good question, Stephen. And I've done a lot of different activism in my life as an academic. I describe myself as an academic activist, actually. And I have certainly, in terms of regulators of the legal profession, worked very closely on the potential for self-regulation and, codes of conduct, codes of practice. But what I've seen over and over again is that if you really want to stop a particular kind of harmful activity happening, it's not enough for people to say, we'll try under normal circumstances not to do that. When I negotiated my settlement agreement with the Anglican Church for my own abuse, I asked them to, I worked with them as my settlement on a new claims process. And in that claims process, one of the provisions, there were many things that I know have made the process much better for people. But one of the clauses there was that they would only use NDAs in exceptional circumstances. And when I think about that now, I want to like bang myself on the head, because obviously every circumstance then becomes exceptional. We've seen some efforts to produce guidelines for, and I'm talking about lawyers specifically here, in the UK, and they have been completely toothless. And I think that members of the public and those whom I worked with as self-represented litigants will be able to attest to just how difficult it is to bring a complaint about behavior that appears to breach those kinds of self-regulatory guidelines to an organization that is essentially policing itself. And that's why myself and Zelda, whilst we are still pushing for voluntary pledges to try to change public awareness and the sort of cultural context, and we have managed to secure those in relation to many universities now, some corporations, and that has been followed up with legislation on universities not using NDAs in both England and Ontario, Canada now. The ultimate goal here is going to be legislation, because that's the only way that we're going to be able to actually ensure that people are not asked to sign these agreements.
Let's take a quick break to talk about SwiftFox. Every moment on a campaign matters. You need the tools that you can trust. Lists that are up to date, absolutely. Phone banks that can change minds. Emails that drive donations, and events that will energise the community online and offline. And text blasts that distill your message perfectly. SwiftFox CRM is made for campaigners by campaigners. And to find out more, go to swiftfoxcrm.com to win your next campaign. Okay, let's get back to the show. You've started to touch on some of the successes you've had there, both in Ontario, Canada, and in the UK. Give us a sense of where you're making headway, or where this movement, this push, this campaign is making headway in terms of getting legislative change, and how have they gone about this?
Well, we have worked in the campaign, we've worked with legislators in the Republic of Ireland, which has adopted our model bill to ban NDAs in relation to sexual harassment and misconduct, harassment, bullying, and other forms, any form of discrimination. Those are, that's our scope at the moment. Although I would say, Stephen, that it's important for people who are listening to know that NDAs are going to appear in the contract with your realtor. They're going to be there in the resolution of your consumer dispute. This is all over. But we're starting with workplace misconduct, which I describe as the low-hanging fruit here as a first step. And Ireland is passing that legislation through now. In Canada, we have legislation moving forward in two of our provinces, Nova Scotia and Manitoba. It has already been enacted into law in Prince Edward Island, and it is about to be introduced into Ontario for other than universities, all workplaces, and also in British Columbia. I'm also working with the federal government, who have a very small jurisdiction over employment in Canada, but nonetheless are important as employers, and we know that they're using them to NDA public sector civil servants as well. In the United States, I think we're now up to 16 states which have legislated to ban NDAs in relation to specific tranches of issues in relation to workplace misconduct. And in the United Kingdom, there has just been legislation passed, as I mentioned, to ban NDAs in universities, and another private member's bill being brought forward to make that apply to all workplaces. So we are actually seeing an extraordinary amount of progress in a very short period of time. And I think the reason for that is because there is, and this is one of the goals of our campaign, more and more public awareness that we're not just talking about Hollywood stars here. We're not just talking about sexual harassment. We're talking about, for the most part, the people who are impacted by NDAs are in low income, vulnerable, insecure employment. They make these settlements because they just don't feel they have any other choice to make them. They rarely, if ever, understand at that moment what it is that they're signing, but what they don't anticipate, and I think, to be fair, Liberty's point, neither do their lawyers historically, the long-term consequences of being told that you cannot speak about what happened to you, which, by the way, also includes telling the next place you go to for a possible job opportunity why you left the last place. So, this really does kind of dog people and follow them for the rest of their lives. And I do want to just say that if there's anybody listening to this podcast who is currently being pressured to sign a non-disclosure agreement for a workplace termination or some other kind of an issue, what we say to people is, remember, it's the party who is pushing you to sign that NDA for whom no publicity is the most important thing. And so when they tell you they're not going to make an agreement with you and they're not going to give you any money unless and until you sign the NDA, it's worth saying, no, actually, I'm just going to sit tight and sure, take me to court, because it's actually all a bluff, Stephen. The people who want you to sign the NDA are the same people who the last thing they want is to be in court, because then they're in the public domain and all the information is public. So this has been a very successful kind of smoke and mirrors exercise for a long time. And what we're trying to do is to empower people to realize they really do have agency to say no. And they can also at the same time demand a confidentiality agreement to protect just them, but not the other side.
It's interesting listening to you there and thinking about that through the lens of, say, like a community organising campaign. And if there was some sort of umpire of a community organising campaign between the two sort of campaigns, they said, okay, I'm going to remove one resource that you, the community, can't use as leverage, and that is the media. We'd be like, well, that makes it tough now, doesn't it? And it's exactly what's happening in these negotiations. It's nonsensical. Liberty.
Well, I mean, I think that just to be clear, Stephen, I think that for the individuals, and I have worked with hundreds of these people now, and I know Liberty works with people who've been affected by sexual harassment all the time. What's important for them isn't publicity. What's important for them is to be able to talk to their family, their friends, to talk to their therapist, to recover from the harm that's been done to them. Now, in terms of talking to media, sometimes when you can't get anybody to do anything, that's what you do. And I've certainly used that over and over again in my own activism. But, it is perfectly possible, of course, to say, well, I want to be able to talk to all the people within my own circles that I want to. But sure, if I'm going to talk to media, we'll say this is what we're going to say, but it has to be possible to disclose this. We're just not used to seeing this being reported. There has been misconduct. There has been a settlement, and it has to be possible to say that, to get that to the level of public consciousness.
Lib, Julie's lifted up some examples of progress with legislative reform across various sectors in the Northern Hemisphere. All eyes on Australia right now. Where are we with making progress in terms of getting legislative change to ban these NDAs?
Lots of positive progress here. Firstly, in response to the recommendation made by our task force to ban non-disclosure or confidentiality agreements, the Victorian government has committed to undertaking a further review, but have agreed in principle that that's the right way to go. And so they're working on that at the moment. We've also seen a change of government at the federal level, as your listeners would be well aware. And with that came a commitment to introduce all of Kate Jenkins' 55 recommendations, which included the positive duty to be placed on employers. Now, just so everyone's clear, that positive duty has existed in the Victorian Equal Opportunity Act for some time. It's now part of our Commonwealth Act. And what that requires is that employers have to turn their mind to how they're going to make their workplaces free of sexual harassment. This happened at the same time as we've had a number of other really high quality and good discussions from employers, not all, but some, via the Champions of Change coalition, who have guidelines on how to use or not abuse non-disclosure agreements. We've seen the Australian Institute of Company Directors teach those that go through their program about what the obligations are of a company director when it comes to managing your workplace culture and how to use the occupational health and safety framework as a mechanism to do that. And we've seen other organisations, particularly those within the superannuation sector, come out and insist, in fact, that employers take action on transparency when it comes to workplace sexual harassment. So we now have some big employers in Australia that have taken a public stand and now are doing a range of things transparently around workplace sexual harassment and not using NDAs as a result of that. In fact, a shout out to one of my fellow inquiry members from the inquiry that we held into gender equality over the last couple of years with Carol Schwartz and James Fazzino. James, who is also a member of the Champions of Change Coalition, himself is a director on a couple of boards, and he's told me that since engaging even more thoroughly with this issue through the inquiry process, the companies that he's engaged with will not impose NDAs on anyone, and in fact will also release those that had previously signed NDAs from those obligations. So there are a few examples, but I think what in the background of all of this, we have metoo. I mean, in Australia, we're all living through the Grace Tame and the Brittany Higgins issues. We're seeing reform in our Australian Parliament around how the Australian Parliament, the place that should be the most model of workplaces, is going to tackle what clearly has been a big issue around culture, particularly with workplace sexual harassment. We're seeing a shift in expectation and an increasing momentum for employers to take appropriate responsibility for their workplace cultures. Part of that, and part of the transparency around that, is to say goodbye to the past and the use of non-disclosure agreements. They're absolutely a discredited, outdated tool, and their leadership in this area is very helpful when it comes to stamping out the scourge of workplace sexual harassment. So we're seeing a combination of levers. We're seeing legislative change. We've seen good Labor governments who understand that the way to address these structural issues is through a structural solution, which will require legislative change. But we're also seeing employers and their representatives come to the party knowing that this is now no longer good for business.
Julie, can I ask you, I understand there's an argument floating around in this space about the victims and whether or not they themselves want to enter into a non-disclosure agreement or not. And I think the argument is that you're taking away their agency by placing a ban on NDAs. Can I get your thoughts on that?
Yeah, I'm sorry, I'm smiling, Stephen. It's just, I could bring you hundreds of people who signed NDAs who would just go berserk if they were being told that. What victims are being told is this will give you closure. You should sign this, it will give you closure. Surely you never want to think about it again. And as they will tell you, if you were to ask them, and they have told me over and over again, this is the opposite to closure. This is about walking around with a monkey on your back for the rest of your life, worrying about breaking an agreement. And when it comes to agency, that is just not the reality of what's happening in these processes. We hear from people over and over again, and I would invite listeners to go to our website, can'tbuymysilence.com, and look at our testimonies page, where we have been publishing people's anonymized testimonies about their NDA experiences. And over again, they tell the same story. I was pressured. I didn't understand it. I asked my lawyer if they had a lawyer, and they said, oh, no, it's normal practice. Everybody signs this. And it is amazing to imagine, for me, that anybody could possibly see this as victim agency. Victim agency would be saying, I want my privacy protected, but not only on condition that I stay quiet and protect the privacy of the other side. That would be agency. But this isn't agency. This is bullying, this is coercion, and this is ultimately not good for people. One of the things we have in our bill, in our model bill, is a clause that says that every agreement must include a waiver that would allow the victim or the complainant to change their mind. There are many, many other conditions, by the way, in there, but one of them is they must be able to change their mind, because if everybody's saying this is for the victims, then give them the chance to have second thoughts about it. And of course, any lawyer will tell you it's completely pointless to sign an agreement in which one party can simply get out of it whenever they feel like it. So this is just a way of making them basically unenforceable. But if you turn this around and say, okay, so what is it that's so great for the victims here? Nothing. They want their own personal privacy, and they may want to speak more widely, but most people don't. Most people simply want to be able to go on with their lives, but be able to live out what has happened to them in their own family circles or with their therapist, or perhaps be able to give information to a new employer that they were bullied out of their last job. So what we're doing is absolutely the opposite to giving victims agency. And as I say, I invite people to go and look at those stories. And again, I know there are going to be people listening to this, because we know, Stephen, that there are enormous numbers of people out there who've signed NDAs. And I don't want any of them to feel like they've done something stupid, because we all understand the pressure that people are under at these moments and the lack of complete understanding they might have about the long-term consequences, which is what Liberty and others have attested to, and you too, in your union experience. But what I want people to understand is that, they're not good for victims. This is not what victims want. And if we're really going to put, a focus on taking care of people, then it's got to be not just these victims, but also the next victims, because by allowing people to continue with this behavior through an NDA, there are going to be more and more and more victims. So I'm sorry. I think that the victims, this is victim agency is a completely distorted idea of what actually goes on in reality in these processes.
This is a primarily an activist-based podcast, and I just want to ask some questions of the campaign that you've been leading. Obviously, you've got a legal background, you've got an academic background. Starting with what is the strategic goal for the campaign? And you're obviously operating across various countries and different jurisdictions. I'm really interested in getting a sense of what does success look like for the campaign, and then I want to kind of sort of talk a bit about how you're actually managing to get that. What resources are you organising in a way to create that change?
Right. Well, first of all, yes, I have a legal background, and yes, I have an academic background, but I have been doing legislative lobbying and reform work since my early 20s, actually. I worked on, for example, the banning of corporal punishment in schools in the United Kingdom in the 1980s. I wrote the legislation that was eventually used there. And we were, of course, also told, it's such a familiar theme, we were also told that was good for people. It's amazing how many things we're told are good for people, which are actually shit for them. And, I have seen throughout the work that I've done a need to try to translate what we learn through research, and I've always been a researcher, into real life practice and make a difference for people. So the campaign, which by the way is myself and Zelda Perkins, we are partners in this work. She focuses mostly on the United Kingdom. I focus mostly on Canada, but we both work in other places as well, and we speak every day. Our goals are to raise public awareness of this issue, to begin by encouraging voluntary pledges, the kinds of things that Liberty has been talking about, to start to get cultural change happening. We just last week got the Canadian Bar Association, which is the members association for all lawyers in Canada, to vote to strongly discourage their members from using NDAs in these circumstances, and to lobby government for legislative reform. So that's not a change in law, but it's a very important step in terms of changing the culture. Thirdly, for legislative reform, which we see as the real goal here, to change the law so that these are just take the toys from the boys, take it off the table. Don't try to make them better, just take them away. And we are also trying to offer a safe space for people who have been personally affected by this to come forward, share their stories, and read the stories of others. It will be another step again to have those folks released from their NDAs. And hopefully we can, once legislation is in place in enough places, shame corporations into releasing people, because I don't think it's going to look very good for business if you go and sue somebody for breaking their NDAs these days. But that's just starting to change. And we need to push that further down the road to make these, if you like, toothless going forward.
And Julie, sorry, Stephen, if I could just jump in. Did you explain at the start who Zelda is?
No, maybe I didn't. So Zelda Perkins, just so that everybody realizes, was the very first person to break her NDA with Harvey Weinstein. So Zelda worked for Harvey Weinstein in the 1980s. She was an assistant. She worked on film production. And she, along with many, many other women, of course, we now know this, signed non-disclosure agreements, which is why it took 20 years for this to come out about Weinstein. She was the first extremely courageous person at a point when it was still looked likely that she would pay some heavy consequences. She publicly broke that NDA. And Zelda describes that she didn't have legal background. She actually thought that she might go to prison, but she had decided that she was prepared to go to prison, which didn't happen, but she was prepared to do that if that was what was necessary in order to tell the truth and to prevent Harvey Weinstein continuing to do this to other women. And, one of the things that Zelda and I agree on absolutely is that speaking up about this kind of behavior, calling out bad behavior, shouldn't be seen, as it still is, as somehow brave. It should be normal.
Great question, Lee, because actually the question I was about to ask was stories of people who have been impacted in a campaign, and in this case, the experiences in workplaces can be a critical tool.
Absolutely.
But here's a challenge. A lot of the people impacted by this have signed non-disclosure
agreements. Correct, right.
So how do you share those stories? Zelda obviously is I hope not a unique example, but certainly a very powerful one, because obviously the media, we all, this is a global thing, right? But leaving aside Zelda for one moment, have stories been important in your campaign? How hard has it been to get folks to share those stories, knowing the implications, and talk about how do you treat them? Because you have to be careful with that, right? But at the same time, I just want to get my head around how you build to the work you do.
No, absolutely. I mean, first of all, completely agree. All the campaigns I've worked on have all been very deeply rooted in people's personal experiences. And those stories are the way that I think we reach a much wider audience. I mean, my own research is also storytelling. It's qualitative research. So what we've done in the campaign is we have set up this testimonies process where people will send their anonymized experiences to us. And we will, as I said, very carefully vet them. Those stories are used constantly by journalists for stories. We also ask people, obviously we have their names and we have their details confidential, and we also ask people if they are willing for their story to be used on an anonymized basis by media or on social media. And we also always check when we're asked, do you have a story about somebody who was NDA'd for a disabilities issue? Do you have a story about someone who was NDA'd for sexual assault? Whatever it might be. We will go back to our database, we will contact those people, and we will ask them if they are willing. But you can simply go on and read the stories as well. We're also always looking for places that people can tell their stories and be protected. So recently we got a bill through to the committee stage of the process in the province of Manitoba. And at the committee stage, the public in Manitoba can make representations to a smaller group of lawmakers. And because those hearings are covered by parliamentary privilege, which is the same in Australia, it meant that I could put the word out to people and say, look, you can come and talk about your NDA. You can break your NDA. You can tell these lawmakers why they need to ban them, why they did not give you victim agency. And you are safe because parliamentary privilege will protect you. And you can go and look again. You can find this link on our website. You can go and watch over 6 hours of testimony of nurses and firefighters and teachers and IT workers, you name it, talking for the very first time about what happened to them and their NDAs.
If someone wants to contribute or support the work that you and Zelda are doing, how do they go about doing that?
Well, absolutely, please get in touch. We are a completely volunteer organization at this point. We have one person, the wonderful Stacey, who we managed to scrape together a few hours of payment for every week. We rely entirely on donations, so people can donate and anything helps. And if people have particular skills that they would like to help us with, we have, been so fortunate to benefit from volunteer fundraisers, volunteer people who are journalists, who have journalistic expertise, can help us with media, people who have all kinds of different skills contributing to the campaign. And we have a lot of work to do. We're always looking for legal researchers because wearing the hat of the legal person in the campaign becomes rather heavy if I'm the only person wearing that hat. So really get in touch with us. All the information is there on the website. And I think that one of the things that is clear is that for people who've been really affected by this experience, and also for those who have now changed their minds and recognize that it is not helpful to do an NDA, this can be a very empowering and even cathartic thing to do to help us work on the campaign. And of all the campaigns I've worked on in my life, none has ever moved faster than this one. So it's a wild ride. It's not boring.
That's a great field pitch for anyone that wants to get involved in this particular campaign. So we'll drop the details in the bio for this week's episode. So please click on that. And then I've been on the website myself. There is places where you can donate, and obviously all the things that Julie just mentioned. Please get involved and support them. Liberty, before we go, is there anything that you want to lift up in terms of what's happening here at home in which people can support the work that either Maurice Blackburn are doing or the task force, or what's next? Where does the story go here in Australia?
I think just stay tuned. There's a campaign that the Victorian Trades Hall Council are going to run on this over the course of the year, so they can get involved and stay connected with that. And as the Victorian government progresses its thinking on it, get in touch. Let them know what you think about it. If you're in support of it, they'd love to hear from you. So stay tuned. We'll also be engaging with the federal government to see whether they have an appetite for a legislative ban. And again, get in touch with the local MP and let them know what you think.
Julie, thank you so much for your time.
Thank you very much for having me. And Australia, get on board. This train is rolling. Thank you.
Fantastic. And Libby saying a thank you. We'll see you in a month's time for our annual International Women's Day podcast. Look forward to that episode with yourself, the Minister, Nat Hutchins, and Julia Fox from the SDA.
Terrific. Looking forward to it.
Thanks, guys.
Thanks.
Thanks for listening to Socially Democratic. Did you like the podcast? Hit the follow or subscribe button and be sure to leave a review on Apple Podcast or Podchaser. And to get all the latest on Socially Democratic, follow Dunn Street on Facebook, Instagram, Twitter, and LinkedIn. And we'll see you next Friday. Socially Democratic was brought to you by Maurice Blackburn Lawyers. Maurice Blackburn Lawyers have spent more than a century paving the hard path to justice for everyday Australians. They've helped over 500,000 Australians turn their situation around, and they know how the system works. Their experience and skills means you'll get the best results possible. Find out more on their website, mauriceblackburn.com.au. Maurice Blackburn, experience you can count on. Socially Democratic was brought to you by SwiftFox. Every moment on a campaign matters. You need the tools that you can trust, lists that are up to date, phone banks that can change minds, emails that drive donations, events that will energise the community online and offline, and text blasts that distill your message perfectly. SwiftFox CRM is made for campaigners by campaigners. To find out more, go to swiftfoxcrm.com to win your next campaign.